Oyez, oyez, oyez. The Honorable Court of Criminal Appeals is now in session.
Good morning. The COVID-19 pandemic required many adjustments of the justice system. Social distancing and group size restrictions, as well as substantial hardships on counsel traveling to Austin, do not allow us to hold arguments in the courtroom. Rather than submit cases without argument, we have decided to proceed through remote connections. Court staff has made every effort to prepare us and counsel, but of course there may be glitches that will require patience. Otherwise, we will proceed as we would in person. The arguments are being live streamed this morning, and a recording will be available later today. We're ready to hear argument in cause number PD-1049-19, Zaid, Adnan, Najar versus the state of Texas.
May it please the court. My name is Jessica Caird, and I'm an assistant district attorney in Harris County, representing the state of Texas in this matter. The Court of Appeals held that a siren heard in the distance was other evidence received during jury deliberations for which the trial court had no choice but to grant a new trial. It did this based on the affidavits of 2 defense attorneys and without regard to 606B's prohibition on such evidence.
Counsel, is there a distinction between other evidence that's detrimental and outside influence?
The way that the courts have tended to look at this, and this court hasn't specifically spoken on the impact of 606B in 21.3F, the other evidence received, is how the evidence can come before the court, how the court can hear that evidence and how it can consider that evidence, if it can consider that evidence. So it's almost more as a confining area of where the evidence can come from in a 21.3F analysis. Would the court like to briefly hear the facts, or are you familiar with them? Just briefly, I would say that it was an evading by motor vehicle case. The appellant was seen driving about 100 miles per hour on the 610 highway in a somewhat congested area. He had red and blue flashing police lights on the front dashboard of his car. When the officer realized it was a personal vehicle, not a police one, the officer flashed his own equipment and appellant turned his off. The appellant, however, continued to speed. The officer followed him back and forth across the highway from the far right to the far left to the far right, twice as the officer closed a distance in the far left lane. It took about 2 minutes and took about 2 miles and went about 1 minute to 1 minute 45 seconds before it all was completed, when the officer was between 10 feet and 25 feet behind appellant. Going specifically into the 606B prohibition that Judge Newell mentioned, 606 really does confine the kind of evidence that the trial court can hear in this matter. It has a large variety of policy reasons this court has gone over time and again, such as the need for privacy in jury deliberations. Jurors need to feel that they can talk about all the issues freely and then come to a conclusion. They don't want to be harassed for months or years later. They don't want to be followed, and there doesn't need to be a risk of some tampering to try to convince a juror to change their verdict well after the verdict has been received. In this case, it was 2 affidavits from the 2 defense attorneys with the grand total of 2 sentences in each affidavit with slight discrepancies between them about a conversation that occurred after the verdict was received with the jurors.
Counsel, if the state had objected, would it have changed the analysis at all, or would we still be talking about outside influences?
I believe the court would still be talking about outside influences. 606B is clear that it is something that cannot be received by the trial court. Unlike all the other rules of evidence, most of which refer to admissibility, this simply says that the trial court may not receive such evidence if it goes into jury deliberations unless it meets one of those 2 exceptions. The only important one here being an outside influence improperly brought to bear on the jury. To be an outside influence, it has to be something outside the juror's personal experience and knowledge. It has to be something that is new and brought from outside the jury into the jury, such as in McQuarrie, where it was outside research that was brought back to the jury. It also has to be something that's improperly brought to bear. That means it has to intend to sway the jurors from one side to the other. It has to push them in one direction or another. This was nothing but an extraneous sound, a neutral influence, if any. It was really no outside influence whatsoever.
So it's your position that a siren is just something so ordinary that it didn't matter at all?
Correct, Your Honor, and certainly that's what the dissent felt as well. I mean, it'd be hard pressed to find somebody in Harris County, Texas, or any metropolis area that hasn't heard a police siren, a fire siren, or an ambulance siren. In the end, we don't even know if this was a police siren because that's not in the affidavits. We know very, very little from the affidavits. They're really basically conclusory in most ways. They talk about what one juror said, and then the one attorney says that influenced the verdict, and the other attorney says it was considered by the jury as a whole without any reference to why or how they believed that or how the attorney came to that conclusion. And the second sentence was mainly a matter of opinion. They believed that if they could hear a siren, that the defendant could have heard a siren or would have heard a siren under similar circumstances. In the end,
Is there any reason that the state did not offer a countervailing affidavit?
Your Honor, they did offer a countervailing affidavit on the secondary issue, the ineffective assistance claim. On this issue, to do so, they would have had to violate 606B themselves. And we know from closing argument that the prosecutor was arguing that this was information the trial court should not consider because it was not an outside influence improperly brought to bear. By offering a countervailing affidavit, they would have themselves violated 606B by going to the jury and continuing to harass them and try to get specific instances that happened during deliberations and try to get how it influenced the juror's vote, which are all things that 606B bars the court from receiving. And that would be one of the many reasons the prosecutor chose not to do that. We also don't even know if the prosecutor was present for this. I know counsel believes they were, but that's not what the evidence tells us. The evidence tells us only that the prosecutor was invited to speak with the jurors, not that the prosecutor went. We also don't know if the judge was present when this conversation took place because neither of the attorneys could remember if the judge was present. Whereas similar to Dixon, had the judge been present, the judge could rely on their own recollections, their own understanding of that conversation, which would be one of the implicit findings that the Court of Appeals failed to utilize to allow the trial court the discretion it needed in order to reach a decision on a motion for new trial.
Counsel, 606B, you said earlier, 606B prevented the prosecution from talking with the jurors, but we have cases where when there's no objection from the state or the defense, and then you can litigate all of these things without regard to 606B. Isn't that sort of one of the reasons why the Court of Appeals is saying they didn't raise the objection to 606B, so therefore the concern is that about outside influence and that they haven't really waived, the state sort of waived the argument that this is improper to consider?
Well, under 606B, it's unclear that the state really can waive that. However, if the court is to conclude, and which I don't think it has clearly ever said that that is a waivable issue, that if it is waived, we still have to recognize that the trial court, as the finder of fact, gets to weigh that evidence as it sees fit. It can believe some, all, or none of an affidavit. And part of what would be one of the considerations to weigh, and certainly what was argued in closing argument here, was that it's not an outside influence. It shouldn't be considered. It wasn't improperly brought to bear on the jury. It was part of their personal knowledge and experience, as most people find. Also, you have to look at the fact that the trial court can choose to believe it if they do. I mean, it's how they weigh it. In addition to it being a violation of 606B, it also was clearly hearsay. It was the attorney relating what someone told them, and possibly hearsay within hearsay, because it can be read as one juror describing what other jurors said, thought, or believed. That would certainly be hearsay within hearsay, which is again something.
So is your argument then that the judge could have simply just found the affidavit to lack credibility, or are you saying that the judge could have chosen to disregard it because they can apply a 606B analysis even when the parties haven't made the proper objection?
Both, Your Honor. It could be either or. This court, we do not know if the trial judge weighed it under 606B as clearly as we did in McQuarrie versus State, where the trial judge just said, I'm not weighing this. I think it doesn't come in under 606B, and did so without necessarily an objection. That was the trial court making that statement. In this statement, we have only implicit findings because the trial judge didn't step in and say what her thought process was beyond saying it's part of the personal knowledge and experience. That could be under a 21.3F analysis, or it could be part of a 606B analysis because they both utilize that to a degree. So the short answer is we don't know if that was, but as a fallback, there's no way that this is still something that the trial court had to assess. It still had to weigh and be the decider of historical facts. And that's something where the Court of Appeals just decided to step in as a secondary fact finder and say, no, we think you had to believe them. And there certainly wasn't enough here that would be anywhere near the level that the trial court was required to believe it. This court has distinguished an undisputed fact from an uncontroverted fact. This was at best uncontroverted, and as uncontroverted, this court said in Collier versus State, the trial judge still has the right to disregard it.
Did the defendant testify and claim that he did not hear the officer's siren?
There was no testimony from the defense. This was a one-witness case. The only evidence was from the officer. Nothing was in front of this jury to say what the defendant thought, believed, felt, saw, or heard. They simply didn't have that evidence. They only had what the officer said, which is that any reasonable driver would have known that he was trying to stop that car, and that other drivers were yielding the right of way to him and getting out of his way at night with his lights and sirens. It's not simply a siren case. This wasn't middle of the day. The officer had his lights going as well. It was at night. They were clearly visible to the other drivers. That was the evidence that was in front of the jury.
But didn't we say in Collier that information conveyed with no intention of influencing the verdict is not brought to bear on the jury and therefore does not meet the requirements of 606B, period?
Absolutely, Your Honor. That was clearly the case in Collier versus State. It has to be intended to influence them in some fashion. This was nothing but neutral. It was an extraneous sound. So there was nothing that was going to sway a jury one way or the other. And that goes to the secondary half of the analysis that the trial court was expected to follow. Under 606B, they're not supposed to look at exactly what this jury thought or believed. They're required to apply the hypothetical average juror. They're supposed to say, would this have influenced an average juror? Merely hearing a siren outside, likely to influence the average juror? The trial court was well within its rights and well within its discretion to say, no, I don't think it meets the test. I don't think it was likely to have been an outside influence improperly brought to bear. But even on the secondary issue beyond that, the court had additional discretion. Even under a 21.3F analysis, the trial court had discretion to say this wasn't other evidence, because if it's personal knowledge and experience, it's not other evidence. It also has to be something received by the jury. That means it looks at how much the jury and how extensively the jury considered this evidence. We simply don't know that from the affidavits. It's not in there. Could have been a passing remark. It could have been innocuous. That's very unclear from the way the affidavits phrase it in the 2 sentences about this, which would be not received. The court had discretion to find that as the fact finder. And lastly, the court had discretion to find that it wasn't detrimental. To be detrimental, it had to be something that was new or hurtful that would have changed the analysis any. The sound of a siren simply wasn't new. It was something that anybody of voting age who's able to be on a jury would certainly have heard at some point in their lifetime. Sirens are loud. Everybody knows that. They're intended to be loud. We knew from the evidence it was used to make other drivers get out of the officer's way, to yield the right of way. That's what they're for. They're meant to draw attention. That's why they're loud. That's why the lights flash. That's why we have all of these things to let somebody know that an emergency vehicle is demanding the right of way. That's not.
At bottom, what I'm hearing is I'm hearing a lot of sort of procedural things on top of what sounds like a very common sense sort of observation, which is it's a sound. The jury heard a sound, but that's something they would have been familiar with. So why are we even talking about this?
Exactly, Your Honor. And that's because the Court of Appeals came as a secondary fact finder to decide that was suddenly new hurtful evidence that the trial court didn't have to decide. It was an extraneous sound that most anybody had heard that would be unlikely to sway anybody. It goes back to that personal knowledge and experience comment, which actually weighs under both outside influence and it weighs under other evidence. It simply didn't amount to it. It's something that wasn't brought from the outside in that was in any way likely to sway an average juror. Even under the analysis under 21.3F, it still looks at the character of the evidence. And this simply wasn't something that was likely to sway a jury one way or the other. It didn't have a character that would have changed the analysis any or the outcome. At best, it might have just been a simple extraneous comment that a juror made during this conversation with the defense attorneys after the verdict was received. Maybe an explanation or maybe an apology. None of that's in there. All we know is what the trial court had in front of it in these affidavits, which was very brief and very conclusory.
I guess what I'm getting at too, though, is that it seems that the Court of Appeals is drawing a distinction between the other evidence detrimental and an outside influence in order to say that there was a waiver of a 606B on the part of the state. Is it your, and so now what I'm hearing, and I guess I'm asking is your position that the outside influence evidence analysis is going to be the same analysis as determining whether or not evidence was received and detrimental?
Not the same, but it's a subset. It's a component for what evidence the court can consider. So in the first level, this wasn't evidence the court can consider because it violated 606B. That means they couldn't receive it, they couldn't weigh it, they couldn't consider it. But even if the court is to find that it is waivable, if the prosecutor doesn't object, the fallback would be clearly that this is a situation where the trial court had discretion to find under 21.3F. It just didn't meet the test there either. We tend to rely on the 21.3F case law based on pre-Texas rules of evidence case law, and certainly pre the current incarnation of 606B. Remember the history of this, which the court went through in Collier, went through in McQuarrie, and it certainly is extensive in Golden Eagle Archery versus Jackson, talks about in 1983, the civil standard changed. But it wasn't until 1998 that the standard changed for criminal cases. And we're still talking about case law that the Court of Appeals relied on from 1977 and 1981. They simply used an antiquated standard that doesn't properly apply the 606B analysis for whether or not this was evidence the trial court could consider and how it had to consider it. It just stopped the trial court from having any discretion whatsoever based on this theory that it was an undisputed fact. But an undisputed fact is something that the trial court can take judicial notice of, which certainly isn't a conversation. That doesn't meet the qualification there, or something that was
there some, excuse me, was there some issue raised during the course of the trial that the defendant did not hear the siren?
There was argument.
That's their argument. Did he testify?
No, he did not testify. It was only the police officer who testified. So if you look at the motion for new trial, that was the basis of this, the only citation made to it was to closing argument, which argument, as we all know, isn't evidence. In the appellate briefing, counsel has referred to some cross-examination questions, but again, questions aren't evidence, and the officer didn't state an opinion one way or the other beyond the fact that he thought any reasonable driver, based on the reactions of the other drivers, would have known that he was trying to stop that person. That's the.
But there wasn't anything in front of the jury that would require them to decide if the defendant heard or did not hear the siren. He didn't testify. Anybody testify on his behalf?
Absolutely not. There was no evidence from the defense whatsoever. It simply was not a disputed fact in the case. It was part of the argument in hopes of getting a not guilty verdict.
Okay.
Counsel, you say there was no influence by the siren. I think that's a stretch, because it does seem like there was some influence, but of course 606 requires it to be improper. And I don't think that there's anything in the record that indicates that any party tried to encourage the playing of a siren while the jury was deliberating. Is that right?
You're correct, Your Honor. And that's one of the things the dissent pointed out. This was not something intended to influence them. It was merely an extraneous event, which is exactly what 606B says we're not supposed to go into during jury deliberations. If the jurors were, driving into the courthouse that morning and heard this, there'd be no question that this is something that, if the juror had mentioned, would be improper to have come about in a motion for new trial. It wasn't evidence the court could hear, because it goes to an event. It goes to how it weighed on jurors. Even back before the rules of evidence came into place, jurors were allowed to express their opinions, which is what was expressed here. And they were allowed to talk about their personal experiences and weigh that in order to figure out what the verdict should be. That's all what we expect from jurors. And there's nothing different that happened here. It was merely a comment that was made after the fact that counsel tried to parlay into a motion for new trial. Without other questions, I will save the rest of my time for rebuttal. Thank you.
Thank you, counsel.
Thank you. May it please the court. The majority opinion in this case properly. Go ahead.
Would you please state your name for the record?
I'm sorry, Jonathan Landers here for Mr. Najar. May it please the court. The majority opinion in this case properly applied 70 years of binding precedent when it found that because there were uncontroverted facts, that means there's no fact issue for the court's determination. That comes from Alexander, Rogers, in cases that started in the 1950s. One thing that the state is misstating is whether or not there was an agreement on the facts in this case. The trial prosecutor, Sarah Neeland, was in the jury room with both defense counsel whenever defense counsel and Ms. Neeland were speaking with the jury. We know that because—
Counsel,
Yes,
what if I can hear my voice echoing. What if the juror had simply said, you know what, I've been pulled over by the cops before and I couldn't hear the siren, and so therefore I don't think this guy could have heard the siren. Why wouldn't that be completely okay?
Well, the problem here is not that jurors do or don't know about how loud sirens are. The problem is whenever a juror takes evidence, it's not from the courtroom, not from the witness stand, and they actually use it in their deliberations to decide whether or not somebody's guilty. So the problem here is not that we have a siren out on the streets of Houston that the jury heard.
In my example,
yes, sir.
That juror is taking evidence and experience from their own life that happened outside the courtroom, and they're relying on it during jury deliberations to make whatever point there is. So I mean, you know, I don't really see how we can say that this siren is an outside influence, but that kind of deliberation I think we have always recognized jurors can engage in is not.
Well, I could give you some case examples here. There's a McGarry case out of Dallas from 1980. In that case, it was a DWI case. One of the jurors, a woman, said, you know, if I had the amount to drink that this gentleman had, the defendant, I would be intoxicated. That statement, which the jury relied upon, was other evidence and required a new trial. In the Alexander and Rogers cases, both from the CCA, the jurors had personal knowledge that the defendant had a bad reputation that was considered. And it's not the fact that they have that knowledge, it's the fact that they used that knowledge in their deliberations and that it was relevant to the case that required the new trial. And so it's okay for jurors to generally discuss their knowledge. You know, we have the Corpus Christi case, the Carter case, where the jury conducts an experiment to see what happened there. It's whenever the jury starts to use things they might already know, but they apply it specifically to the facts of the case, and they say, well, because I know these things, I'm going to treat it as evidence, and I'm going to assume the defendant knew these things. That's the problem. So
they can't use common experiences or common sense when making when they're deliberating.
No, that they certainly can. What they can't do is take evidence from outside the jury room. In this case, the evidence wasn't just a siren. It was a siren that this jury heard up on the 15th floor of the courthouse. They took the fact that they could hear this siren as evidence that Mr. Najar must have heard the officer's siren as he was racing down Highway 610. That's the problem. The inference that because we heard the siren, Mr. Najar heard the siren. I'd like to point out there's absolutely no evidence that Mr. Najar heard the officer's siren in this case. The siren is hardly mentioned in the case. Mr. Najar is speeding down the highway at speeds over 100 miles an hour. He's weaving in and out of traffic.
Excuse me, did the officer testify that he had his siren on?
I think 2 times in the records he testified he put his siren on. Most of the testimony dealt more with his lights.
Okay, but he did say he had his siren on. Did he say for how long he had it on during the chase?
My recollection is Mr. Najar is driving down 610. The officer is on an on-ramp. And as Mr. Najar passes the officer, he turns on his siren and his lights. It's not real clear how quickly, but it is as Mr. Najar passes the officer going 110 miles an hour.
Okay.
So
there is evidence of a siren in the record.
2 times the officer says he turned on the siren, yes.
What is the driver supposed to do when they hear a siren and see flashing lights of an emergency vehicle coming up behind them?
I would think that you should yield to the right, or if you're being stopped, stop your vehicle. There's one other fact that hasn't been pointed out here. It is pointed out in our briefing. The officer testified that for the entire minute and 15 seconds, minute and a half that this chase was going on, there was vehicles in between him and Mr. Najar, and Mr. Najar was weaving in and out of traffic just as he had been as he was speeding down Highway 610. But as soon as the officer was able to pull behind Mr. Najar, the very second that happened, when there was no cars in between them, Mr. Najar stopped and exited to the right. That's the evidence. So the defense in this case was, and it started in voir dire, it was in opening statement, it was in closing statements. As soon as Mr. Najar knew the officer was behind him, he stopped his car. And that's supported somewhat by the record, and the officer, he said it on both direct and cross-examination, he said this. As soon as I was able to pull behind Mr. Najar, he stopped his car. So the real sticking point in this case is when did Mr. Najar know the officer was behind him?
Counsel, are we addressing legal sufficiency, or are we considering whether there was an outside influence?
Great question, Your Honor. This is not a legal sufficiency test, all right?
Then let me ask this. It's something I asked the state I'm curious about as well. The Court of Appeals seems to have drawn a distinction between the Rule 2021 and Rule 606 606B, do you think there is a distinction in the analysis that we're supposed to engage in under 606B or Rule 21? Or is there no distinction?
There seems to be some distinction just based on the case law. So there's a very simple test for Rule 21.3. It's always been the test. It's if the jury received other evidence and it was adverse or detrimental to the accused, that's two rules, two elements, then a new trial is required. The 606B analysis is a little bit more complicated, but not much. So 606B from McQuarrie, we have, it has to be outside influence, so something originating from a source outside of the jury room. In McQuarrie, this court was very clear, we're going to use the plain meaning of outside influence. In Collier, we added a little bit to that. The court added some. And what they added was that the outside influence must be related to the trial issues. And that's where this improperly brought to bear standard comes from. So for 606B, something originating outside of the courtroom and that is related to the trial issues. Our argument is that even had the state made a 606B objection, this particular evidence wouldn't pass that 606B test, and the court could consider that evidence. Now, of course, the state did not make a 606B objection. They affirmatively stated no objection when this evidence was introduced. This court's rule has always been that if you want to make an objection, if you don't want to waive it, you have to object when the trial court can do something about it. And I would like to point out that the idea that Rule 606B cannot be waived or 606 cannot be waived doesn't really make sense when you look at Rule 605. The rule just before Rule 606 states it's not a judge testifying at trial. It says a party need not object to preserve the issue. If the Supreme Court of Texas and this court wanted to make it so that Rule 606 always applied, even if the parties agreed to the facts, and even if there's no objection, the courts would have said that when drafting the rules of evidence. There's no reason to believe that 606 cannot be waived. As a matter of fact, the Lee case that came out of Houston, it's cited in the briefing and it was cited by the majority opinion, specifically held that the Rule 606 objection can be waived. And that was based in part on this court's footnote that basically told the Court of Appeals to address the issue. And if they thought it was waived, just say it's waived. I would also point out that in the Salazar case, this court stated whenever neither party objects, the juror affidavits are correctly before the court. So I do believe that the analysis is similar for this case of the two issues, but 606B simply doesn't apply in this case whatsoever.
How do we know that the trial judge didn't harbor some skepticism about the veracity of the claims made by defense counsel on account of the hearsay nature of their claims?
I think that if you read the court's ruling at the end of the motion for new trial, she does say she relied on the affidavits and she states why she didn't grant this motion for new trial. It's based on the idea that the jurors had general knowledge about how loud sirens are. So I think the ruling is fairly clear. The more important issue for this court, though, and for the Court of Appeals, quite frankly, is the 70 years of precedent that say if we have uncontroverted facts, when we're dealing with 21.3, that's the only time I've seen this. Uncontradicted facts mean there's no issue of fact for the trial court's determination. That's always been the rule. It's been the rule prior to Rule 606, and it's continued to be the rule since then, and it's been followed by all the courts that have looked at the issue. I would point out one other issue, which is this is stronger than an undisputed fact. I'm sorry, an uncontradicted fact. This is an undisputed fact. And it's undisputed because the trial prosecutor was in.
Is this a new term of art? This is really a fact, not just a fact, it's really a fact.
And so it's not, Your Honor, actually. This court discussed this in Collier. So, of course, Collier and on, I think it's, Charles and on Okonkwo. Those are both ineffective assistance of counsel cases. And I don't need to tell this court how deferential that standard of review is. It's very different than 21.3 F review. But in Charles, this court said, look, it explained the difference between an uncontradicted fact that might not be objected to and a fact that would be undisputed, which this court has said is when the parties agree to the fact, which is what happened in this case, 100%, or when the fact could have been easily controverted. So I don't practice civil law, but the court favorably cited the rules of civil procedure that when you have an affidavit that states a fact that could be easily controverted, but it's not, it becomes undisputed, and trial courts are not simply free to disregard that fact.
Can you specify, though, what exact fact are you talking about? Are you talking about the fact that the jury heard the siren, or a fact that the jury was improperly influenced by the siren that they heard? I mean, I think that could make a difference.
I see, Your Honor, yes. So the fact that was agreed to here is, it's more than one fact. It's that the jury panel told all the attorneys involved in the trial that they'd heard this siren from outside, and that the fact they could hear the siren from inside the jury room was considered by the jury as a whole while reaching their verdict. That comes directly from the trial counsel's affidavit. And
But how do we know which parts of that are contested versus non-contested? How do we know that?
I think a straightforward reading of the record on the motion for new trial tells us that if anything in this affidavit had been contested, the trial prosecutor would have spoke up. There's not an attorney in Texas that would allow me on the record to say, we agree that this conversation took place, but not correct misstatements in the affidavits.
Counsel, even if we go at the end of the day, we say, this is an agreed set of facts. The state should have made the argument of 606B. They didn't do it. Aren't we still left going, well, is this siren an outside influence or not?
Yes, I think that's the interesting question in this case, quite frankly. In almost every case in Texas, a siren on the street would make no difference, and it would not be grounds for a 21.3F appeal or no motion for new trial. But in this particular case where the jury had to decide, when did Mr. Najar know that officer was behind him? That was the question. This was not a long chase. This was a short and a fast chase. Mr. Najar stopped as soon as the officer was able to get behind him. The jury then heard this siren on the 15th floor of the courthouse and decided that because they heard this siren, Mr. Najar must have also heard the siren. That was not in evidence. There's no evidence saying Mr. Najar did.
They couldn't infer from the evidence that he heard the siren. They couldn't have just inferred from the evidence that.
There's no evidence about how loud the siren was. There's no evidence that the siren, as opposed to the lights, were what Mr. Najar should have seen. The Officer Bakar's testimony mostly focused on how bright his lights are and how people could see the lights. So they could have, I guess, inferred from that. But what we know from the jury is they inferred that fact finding they made from the siren they heard on the street.
But Mr. Landers, here the defendant didn't even testify that he failed to hear the siren. So how's it a fact issue?
Because there's also no testimony from any source that he did hear the siren. There's conflicting testimony about when he should have known he was being pulled over. Officer Bakar says, look, everyone else was moving out of my way, so I think Mr. Najar should have moved out of my way.
Wasn't he doing 100 miles an hour on 610?
He was, and that's part of the reason why he might not have noticed. And this was the defense. When you're driving 100 miles an hour on 610, rearview mirror. And
I'm evading, therefore I'm not evading.
But wasn't there testimony from the officer that as soon as he turned on his emergency lights, the defendant turned off his bogus lights and accelerated and started zipping in and out of traffic? So right at that point, when the officer's turning on his lights and his siren, the guy starts moving around. So he didn't know he was being followed at that point. I mean, there's more evidence than just he's speeding. He accelerates and turns off his lights as soon as the officer activates his emergency lights.
I certainly recall that the testimony is Mr. Najar turned off those lights on the front of his car as he passed the officer and as the officer started his lights. I agree with that. I believe the testimony was, I believe he was already going in and out of traffic prior to the off because he was driving so fast. He was already going in and out of traffic, and I believe he started to slow down, I think, to 80, basically because he had to over by the Galleria. But I agree, there's sufficient evidence in this case. I'm not saying there's insufficient evidence. I'm saying that Rule 21.3F analysis applies in this case, and it doesn't have a separate harm analysis.
Does there have to be, though, a showing of some sort of intent to influence, that the outside evidence is intended to influence the jury or not?
That is not part of the Rule 21.3F analysis. It is part of the Rule 606B analysis.
So that gets back to the point I've been making.
Okay.
The whole time. Is there a distinction between these two things, or is it the same analysis?
As I said, there are different elements to the 606B test. In this case, I think that Najar passes both hurdles, quite frankly, even if it wasn't waived. I would point out that improperly brought to bear I believe it's the same thing as the intent to influence. It all has to do with, it must be, the outside influence must be related to the case itself. And that would be passed in this case, where the juror, instead of just disregarding the siren, the jury decided, oh, we can hear the siren. He heard the siren. So that was where
But that ignores the other stuff, like the lights and the acceleration. So as far as it actually harming or having an influence on the jury, I mean, you'd have to disregard that somebody, would think, oh, if the police officer is chasing me and has lights, I got to stop, whether there's a siren or not.
Oh, I agree, Your Honor, but we have to remember on Rule 21.3F, we don't have a separate harm analysis. We've got a simple and a straightforward test. That test, I mean, it's in Rogers, it's in Alexander, is that there's other evidence received by the jury, and that it's adverse to the accused. It doesn't have to win the day. It just has.
Counsel, going back to what Judge Newell has been repeatedly trying to get at here is Rule 21.3, you keep emphasizing that the jury relied on other evidence, but the other evidence that you're talking about relies on Rule 606. So Rule 606 has to come into play as part of the analysis of what is other evidence.
Well, we have different language in the two rules. So 21.3 is other evidence. 606 is outside influence. So there's certainly different language there. The court, whenever it adopted the Texas Rules of Appellate Procedure, kept the old language that the legislature had come forward with. So as I said to Mr. Newell, there is a different test for these two things. And especially in this case, Rule 606 has nothing to do with the analysis. It's been waived. Rule 606 is a rule of evidence. So that decides, can we even consider this evidence? Of course, there's no objection here, so 606 is not at play. But
Counsel, I do get that. Like your emphasis in the reason why I thought that the Salazar citation is kind of significant is that's a situation where the state could have objected and it would have foreclosed the entire jury misconduct issue. But I'm getting at with this, I'm not quite sure that an objection in this case would have mattered, because I think we still end up at the exact same analysis of whether or not this siren is an outside influence.
I think that the question for this court, it really is whether or not applying the test for 21.3F, a new trial is required. I think you hit the nail right on the head, Your Honor. And our argument is that by not only hearing the siren, but disobeying the trial court's orders, considering that siren and evidence and using that to establish another fact, that's an outside influence. And if there's no other questions, I'll cede the rest of my time for the court.
Thank you, Mr. Landers.
Thank you very much, counsel.
Thank you.
Thank you, Your Honor. Just to briefly cover some of the issues that appellant raised. The first off is, what is the fact issue, as Judge Richardson was asking about. There were 3 assertions in one paragraph. I think the prosecutor's seen the affidavits. I think we agree that this conversation took place, not exactly what the legal significance of it was, and that we have a dispute about the law, to which the prosecutor said that's correct. It's unclear if she was saying that's correct to any one of those 3 all three of those, but worst case scenario was that this conversation took place, not the legal logical inferences that came from it, not the conclusions the attorneys reached that it tainted the jury verdict in some form or fashion. So at most we say they talked about a siren, as the court pointed out. That's all that the prosecutor agreed to. That certainly comes far below an undisputed fact, one that could be stipulated to because it wasn't, one that the court could take judicial notice of, which it couldn't. So it doesn't carry the weight that the Court of Appeals and appellant would like to place upon it. That's correct, simply doesn't be a wholehearted agreement to all of the facts. A failure to talk about the issue doesn't make it affirmative evidence of the issue.
Counsel, in closing argument, did the defense make any point like the one that counsel makes today that the defendant might not have heard or known the officer was behind him until his car approached the back of the vehicle?
There was argument that the appellant might not have realized he was supposed to be stopped, but as Judge Hervey pointed out, there was a lot of counter evidence to that the prosecutor argued as well, including turning off the bogus emergency lights, including the going in and out. And the officer testified that he closed the distance with appellant in the far left lane before appellant started swerving back over to the right. So it's not as clear cut as counsel would have you believe that it was immediately after the officer was behind appellant that he stopped.
I'm just wondering whether it might suggest that there was a real fact issue that the jury was wrestling with about whether or not the defendant knew that the officer was behind him at the very beginning of this episode.
I don't think there was a clear-cut fact issue that the jury was really assessing there. It was more, was this, they really focused a lot on how far it went, on the 2 miles and the amount of time. I'd also like to point out in response to Judge Newell that the test, although slightly different, is similar, both that the outside influence be something outside the jurors, and under the other evidence analysis that it looks at the character of the evidence. Any way you look at this.
Is there any under either of those analyses, though, that they're similar, there still has to be some idea that this evidence is sort of designed to influence the jury in some way. I mean, it's not like the bailiff bringing lunch is going to be outside evidence.
Exactly, Your Honor. And that's why the court narrowed this outside evidence test for years before 606B came into the picture. It narrowed it because it can't just be an opinion. It can't just be an observation. It can't just be a personal recollection or accounting of what happened.
And there was evidence from the officer that he had his siren on. So siren evidence was already there.
Correct. The evidence was clear that the officer had all of his emergency equipment on and that the other drivers were yielding and that a reasonable driver in appellant's position would have known that he was supposed to stop. That's the evidence the jury had in front of it. So with all of that at play, certainly regardless of whether the court does 606B or 21.3F, the analysis simply doesn't bear the weight of requiring a new trial. Thank you. The state respectfully requests this court reverse the 14th Court of Appeals and remand for assessment of the second point, unless there's other questions.
Thank you, counsel. The case is submitted. The court will stand in recess until 11 o'clock.